submissions on the question of separation of powers. And what has caught my attention is how the three systems of accountability play out in this society. So Parliament has submitted before this court that you can conduct impeachment, or Parliament can conduct impeachment based on its standard, laid out standards. I want you to reflect on what has happened when there was an attempt to pass laws related to recall, which relates to accountability of Parliament. When the Election Act was brought about, Section 45 and Section 46 totally required that for any member of Parliament to be recalled, judiciary would have to participate. An order from the court would have to be acquired first. Then you are told that in impeachment, court has no role because of separation of powers. But in recall of members of Parliament, court has a role. There is no equality when it comes to that question of accountability. That presidency, you do not need courts, but Parliament, you need the court. It is very interesting when you look at the amendments that were made on the Election Act through a bill that was submitted by the Senate, Bill number 29 of 2024, that sought to remove legal justification for recall completely. And so when you consider the question of power, Parliament is simply telling this court that we have the power to do anything because impeachment is our function. But when it comes to judicial review, you should be restrained. That doesn't make sense. In fact, Parliament has gone ahead and sought to limit even the provisions of Article 1, where the sovereign, the people, are given powers to exercise their powers directly by enacting Public Order Amendment Bill of 2025 that seeks to control how Article 37 is exercised in this country. And so Parliament is saying that we have the power even to govern the people themselves in the manner that they would exercise the powers of directly. But when it comes to us as Parliament, do not touch. And that is why there were submissions related to the question of judicial review, whether it's going to dig into the merits of this case. I find it interesting that when it comes to members of county assembly, the County Government Act, Section 27, says that you can recall a county member of Parliament, a member of county assembly, only upon a judgment or finding by the High Court. If these accountability measures that have been provided by the Constitution seeks to limit the power of the court, why is it that then when it comes to county members of assembly members, a court has to participate, but when it comes to impeachment, the court is limited in one way or the other? That's the context that these impeachment proceedings are before you. And it is very important to see the power play that Parliament is actually engaging in. Parliament is claiming immunity, and that immunity, from my view, is trying to put this court under limitations on the question of judicial review. My lady, my lords, Article 10, looked at from the set theory, has certain elements of values. And one of those elements is that of accountability. And there is nowhere that accountability is classified as to whether it's political accountability, economic accountability, or social accountability. It is simply accountability. Such that when we talk of accountability, then it is within its breadth and width. It is not limited in any way. And therefore, all the submissions related to that question, this court must be allowed to exercise judicial review in its entirety. And judicial review in this case must include rationality review. Were those decisions rational? Review of evidence. I listened to submissions from one of the councils the other day, and we were told that 281 members of parliament voted for this motion. What I find interesting in that submission is that you are given the impression of how overwhelming the support was for the motion. But there's something that you're not being told. That never before has Parliament has such numbers when it comes to performing their primary function, which is legislation. My lady, my lords, I find it interesting that 5 times the public participation bill has failed. The first attempt was in 2016. I invite you to just consider those bills. 2016, second attempt in 2018, third attempt in 2019, fourth attempt in 2023. It never passed. The recent one is in 2025. It is very interesting when you look at all those bills and you see the departure pre-impeachment and post-impeachment. The 2025 public participation bill, interesting enough, seeks to say that once public participation is conducted by Parliament, then the Senate may just adopt whatever has happened in the National Assembly, which was not the position in the previous bills. And so, my lady, my lords, we have a Parliament that is seeking to benefit from things that it has failed to do. If you go to Schedule 5 of the Constitution, you will realize that the timelines were very clear. Public participation bill was supposed to have been passed within 3 years. The right of recall was supposed to have been passed within 2 years. None of those things have happened. And at one instance, you find Parliament is able to mobilize 281 members to just vote for impeachment. In other words, when it comes to accountability of presidency, the numbers are available. When it comes to passing and performing the legislative functions, numbers are not available. There is an indictment on Parliament, even in the impeachment proceeding itself. Out of 11 grounds that were submitted to the Senate, 6 of them failed. In other words, 281 members of Parliament passed 11 grounds that could not meet the threshold when it came to the Senate. 221 members of National Assembly. Is the attempt to curtail the powers of this court on judicial review out of fear that the remaining 5 grounds will totally fail. Maybe that's what is driving this question of power. I want to conclude by mentioning a statement that was made by Isaac Newton back in the 17th, 18th century or thereabout. An accomplished scientist. Isaac Newton lost half of his fortune after investing in a pyramid scheme, what we would call in modern day language pyramid scheme. And this is what he said, that I have calculated the motions of heavenly bodies, but I have not been able to calculate the madness of people. the drafters of this constitution calculated everything that they could. Where to place the word shall and where to place the word may. They calculated which institution would have which powers. But I submit before this court that it seems that they had not anticipated the madness of people who are seeking to overthrow the constitutional order and take this country, the Westminster Parliamentary kind of democracy. We are a constitutional democracy. And any attempt to take us in that direction, where Parliament becomes the most powerful institution in this country, as compared to the Constitution, that attempt must fail. In making your decision over this impeachment matter, my submission, my lady, my lords, is that this court must reflect on the exercise of powers by Parliament, because in impeachment, it is the one instance where Parliament is both, not even both, performs investigative powers, which ordinarily are with the Inspector General. It performs prosecutorial powers, ordinarily under the ODPP. It performs adjudicative powers, ordinarily are with the courts. It goes ahead and actually conducts public participation, more or less like an administrative. And yes, these powers are provided, but these powers are not provided with without limitations. There are constraints that are required, and those are the constraints that you're being told by the submissions of National Assembly and the Senate that you should not look into. When you're told not to look into merits, you're being told, we have power, but you and your powers are secondary, or your powers are not at the same levels as ours. I invite you to exercise the full breadth of judicial powers in examining even the grounds of this impeachment and the evidentiary threshold that was provided. For that is our submission. And I conclude by saying this. If this petition fails, I am worried as to the future of this country. We've been told that we may get into constitutional crisis. And I think we've been in a constitutional crisis for the last 16 years. This court should not allow that constitutional crisis to be interpreted by Parliament the way they want to do the interpretation. And that is, my lady, my lords, my humble submission.
Thank you.
Just to put one question on behalf of the respondents.
Yes.
My lord, the parameters of rejoinder are well known, and some are straying outside the limits of that rejoinder. If I may conclude, and the danger with that, my lord, is that it is prejudicial in that the respondents do not have an opportunity to respond. Rejoinder, I believe, is an opportunity to respond on issues of law that have arisen in the response by the respondent. It is not an opportunity to plug any holes that have been made in the response. That happens in the ordinary course of litigation, and we all know that your lordships and your ladyship will resolve those issues as you should. So my request, my lord, is that the rejoinders be confined to what a rejoinder is. And it is not an opportunity to relitigate or to shore up any leaking holes that have been left. Most of that.
I think point is well noted, and
do I have a right of reply to that? Which is something I was anticipating.